Hello and welcome to the Bar Council's Criminal Legal Aid Billing Seminar. My name is Adrian Vincent. I'm the Bar Council Member of Staff, Head of Policy for Legal Practice and Remuneration. So legal practice is anything to do with the courts, and remuneration is anything to do with legal aid fees and private fees. The work involves being executive of the Bar Council's Remuneration Committee. And we are been working with our training and events team to put on these 3 legal aid billing seminars. The criminal one today is the first one. We have the person in behind the scenes, my colleague Georgie Watson, will be pressing the buttons on Zoom to make sure it technically works. For those, it's semi-interactive, so if you are watching, what you is interactive in the sense that there is a Q&A box that should be at the bottom of your screen. At any time during the seminar, if you think of a question, type it into the Q&A box, and then after our 3 speakers have spoken, we'll then move to the times of questions and answers. Don't put it into the chat box, that won't be monitored. Put it into the Q&A box. Your identity will not be known. You'll be an anonymous question, so don't feel embarrassed about what questions you ask. And then we will have 45 minutes of Q&A after each speaker has spoken for about 15 minutes each. The first speaker will be Elizabeth Cooper. Liz is a senior caseworker in the Legal Aid Agency's Advocate Graduated Fee Team. She's been part of the AGFS team since the Legal Aid Agency took over responsibility for the fee scheme in 2011, and she generally deals with the more complex areas of the team's work. Our second speaker will be Mark Spalding, who's a fees consultant of Chambers People with over 20 years of experience as a fees clerk. And then our third speaker will be Tom Little QC. Tom is a member of 9 Gough Chambers. He's Senior Treasury Counsel at the Central Criminal Court. He's a Criminal Vice Chair of the Bar Council's Remuneration Committee and has been engaged in the Bar Council's fees discussions with the CPS over many years, and is the Bar representative on the Appeals Committee. So those are our 3 speakers. So we'll go straight into it, and I invite Liz to start off with your presentation.
Thank you, Adrian. So I've been asked to look at sort of areas where improvements could be made in making your claims so that you get more money out of us. So one of the issues was unused material and how to improve your billing of unused material. Please bill in 2 parts. Make sure you bill the basic fee for the first 3 hours, and then any time over 3 hours as a separate element on your claim. And if you're billing over 3 hours, you must attach form AU1 to your claim on CCCD. Please provide evidence of the number of pages of unused material, and particularly for the larger elements of your claim, the unused material itself. We have to assess the reasonableness of the time spent considering that material. It's very difficult to assess that reasonableness without actually seeing the material itself. We will want, for claims for over 10 hours of consideration of unused material, a work log showing what you've done. The more detail, the better, please. I've seen some work logs that said Friday, 6 hours. Saturday, 7 hours. That doesn't really help. 6 hours spent doing what? What were you looking at for that 6 hours? So that's what we need to see. And please claim for consideration, not for activities. So, or the actions you've taken. So I considered this claim, this material. Yes, that's fine. I drafted these notes and I drafted this application. Well, no, we're not paying for that. And please be prepared if we ask you for access to view the material on DCS, please grant us that access. Okay, some other material that you might like to submit with your claims, particularly for example, offence bans. If it's one way we need to look at PPE to determine offence band, we will need to see evidence of the page count. So it could be the LAA report, it could be notices of additional evidence. If some of the page count discloses that pages were electronic exhibits, then that is something that is not PPE, it's not a page, unless it has been assessed as reasonable to be paid as a page. That's set out clearly in the regulations. So we need to see that material to decide whether or not it can be paid as PPE. So we will actually need to see that material. You can upload it to the Secure File Exchange, also known as GalaxKey, or if it was served on the DCS, you can give us access to the DCS and we will look at it there and assess it from that. Okay, but please, if we ask you for that material, we're asking you for a reason. Something that's sometimes missing from claims as well, the supporting information that provides the detail that allows us to make the assessment and allow the claim as you have claimed it. For example, if you're claiming an armed robbery, details of the robbery and why it was armed. If you're claiming for a drugs offence and the determination of the banding is based on the quantity of drugs, please send us evidence of the quantity of drugs. Actually, you know, whether it was 5 kilograms, 10 kilograms, whatever, there were kilogram quantities of drugs. He was a serious supplier. That doesn't give me the evidence I need to say I am certain that there were over 5 kilograms of Class A drugs here. It might be the sentencing note, the prosecution sentencing note, that indicated that the dispute was out an issue of categorization for sentence. That's fine. We can use that as evidence of value so that the categorization of category 1 matches band 9.1, etc. So anything that gives us proof of the banding that you are claiming. As I've said to various people before, we are not psychic. You know your cases, we don't. We are reliant on what you tell us and the evidence you provide in support of your claim to determine what fee we can pay. And then if you look at the issue, for example, of hardship claims, yes, they can still be made. The hardship only has to be £450. At the moment, we're still not asking for evidence of financial hardship. That may change in the future, but at the moment we are still accepting that we're still in recovery from COVID. We will assume hardship in those circumstances. But please remember, any hardship payment made to the advocate who was dealing with the case at the early stage will be offset against the fee claimed by the trial advocate, even if that is a different advocate. And it is up to you then to sort out with the person who has been paid previously the distribution of fees. We will offset the hardship fee against the final fee claim. So we will get a final fee claim from a new trial advocate, obviously. Sometimes if the advocate who's claimed the hardship fee is the final advocate, they won't submit a final fee claim, they'll just submit a supplemental fee claim for the last few hearings and the sentence hearing to allow us to close out records and make sure that we don't come back to you and say, you haven't billed this case. You said you were going to bill it within X many months. We've got a hardship fee. Is it everything closed out? Please just send us a proper final fee claim with all the elements of the fee claim, and we will offset what you've already had. We're not saying that you're duplicating the fee or anything else. We just need to close out that circle. Okay. And one question I'm often asked, what about Common Platform? Is it staying? Well, as far as I know, it is. HMCTS are still working on the development of it, so I can't see that it will be abandoned. After all, Exhibit is so old that it's creaking at the knees, so they do need to replace it with something, and this is what is being worked on. It is being developed and developed and developed, so it will improve over time. At the moment, there are a lot of teething issues, but we are working to overcome them. And we have regular meetings with HMCTS to work out how we can make sure that what we're seeing when we get a claim in from you in, and we can look at the records, we can see the information that we need to make payment to you. But it will happen. It will eventually improve, but it is a work in progress. And that's it from me. Thank you very much, Adrian.
Thank you, Liz. And now we go to Mark Spalding to give us your insights, please, Mark.
Just unmute me. Good evening, everybody, and thank you to Liz. I'm just going to, there'll be a quick delay whilst I just have a put on a quick presentation for you. I need to do that. Are you able to see my IT?
That's fine. We can see it, Mark. Yep.
What? Right. I've been asked again to cover areas where you might be looking to maximise your claims on here. And as Liz has said, I can only reiterate what she said about the unused material, is that up to 3 hours, everyone gets a fixed fee of £59.09, subject to the date on the legal aid certificate. Now, it seems that only about 80% of the members of the bar are claiming this fixed fee. And it sort of begs the question why. It's there for everyone to claim. And what are the issues in you claiming this fee? When you're putting information on the CCDS, subject to the date of the legal aid certificate that you put in, there's a reminder pops up for you. So why, there should be no reason why you're not claiming this £59.09 on every single advocate graduated fee claim that you submit. If you are claiming over 3 hours, then you claim the hourly rate at £39.39. And as Liz said, you'll need a detailed work log setting out what items you've perused, all the way down, and the date and the time that you did. As a rough guide, the Legal Aid Agency have said that you'll get about 30 seconds for documentary exhibits, invoices and photographs, and up to 2 minutes a page for statements, interviews and medical records. Now, these are only guidelines because you need to claim exactly what you have done and not just base your claim upon the guidelines, because the determining officers will not pay it as a minute per page or anything else. So, you know, as I say, these are guidelines for you to look at. So when you're looking at your unused material, you can claim. And as Liz said, the more information you can give to the determining officer, the better it is from their perspective, and the easier it is for them to pay you the fees. It also might be worth going is that when you do submit your claim, you submit it on the AU1 form, as Liz said, and you provide the unused material disclosure schedules, and or I've found if you're claiming over 3 hours, it's always worth supplying access to the unused material that you've used. Now, either putting on your claim form, asking the caseworker to send you an email and you invite them onto the CCDS system, or in fact physically uploading the material to the Galaxy key into the AGFS scheme if it's over if it's under 10 hours, sorry, under 30 hours. If it's over 30 hours, then it would need to go to the CCU. And as you can see, you need to detail all the work that you've undertaken, submit the copies of the unused material, and you submit it to the CCU team. Another area possibly is not being utilised as fully as it could be is paper heavy cases. Now, it comes under paragraph 17C, so it's part of the special preparation and was introduced in September 2020 changes. So if your PP exceeds offence category thresholds, which I'll come on to, then you can claim a reasonable number of hours to read the evidence above. Again, it's always worth supplying a brief taxation note explaining what you've done and how it fits the criteria, and supply a work log for the work that you've done. And if necessary, you can supply all the documentation that you've viewed to the legal aid agency, again, giving them access to CCDS or uploading it to the Galaxy key. Now, as you can see, the thresholds are quite reasonable for some of the categories, because some of these category of offences, you can get quite serious circumstances for the offence that's been charged, and they can be quite voluminous on the paper. So it's always worth looking at your page count when looking at these. Again, as with the unused material, there is the guideline rates which the legal aid agency will work to, and that's the 30 seconds for documentary exhibits and 2 minutes up to 2 minutes for a statement or something of the same ilk. It's also worth noting that the more information you can give the determining officer, it could allow him to go outside of these guideline rates. So if you've got an extremely detailed, say, expert's report, it might take you more than 2 minutes a page to read that report, but you'll need to explain that to the determining officer so he understands and can reason with you as to why you've taken so long to read this page. So as I say, I'll say several times, is that you'll need to justify the work that you've done. That, I suppose, sums up things in the Crown Court. Another area that's possibly of benefit is some magistrates' court fees, and especially certificate for counsel cases. Where you're assigned under a representation order to present a case in the magistrates' court, you are paid initially in accordance with the rates that are set out in the criminal legal aid remuneration regulations, and these are at in Schedule 4. Now, as you can see, on a straightforward certificate for counsel case, the basic fee for preparation is £468 for a junior and over £4,000 for Queen's Counsel. The refreshers are £162, conferences are £29.25, Written work is a fixed fee of £51.25, and pre-trial review applications and other appearances are £94. So they're better remunerated than a normal standard magistrates court fee. But if you think the case is one of an exceptional nature, then you can argue that the rates that we've just been through do not provide you reasonable remuneration for the some or all of the work that you've undertaken. Now, if we look at it, the divisional court has determined that exceptional means unusual or out of the ordinary, and that it has to be exceptional when compared with an ordinary criminal case, not with other cases of the same type. So if you think you've got an exceptional case on there, then the onus is on yourselves to demonstrate that this provision applies, and you need to provide full particulars in support of any claim under this section. Now, there's certain areas that the caseworkers will look at and the assessors look at, and that is perhaps the character of the defendant. That might be a reason for them to pay these enhanced rates. The weight and complexity of the case, the importance of the case to the defendant, if he's got no previous convictions or anything, or a high-paid director of a company, whereas a criminal conviction could have other implications to him. So these are things that you can look forward to. The type of allegation that's being faced. Again, there's a degree of public interest, the skill, labour and specialist knowledge and the responsibility upon you when dealing with this case. The need for expert evidence, any difficulties with defence witnesses, and the length of the trial. Now, this is not an exhaustive list, but these are sort of to give you ideas on areas to focus upon when justifying your claim for an exceptional case and claiming enhanced rates for your magistrates court work. In addition, if you've got a certificate for counsel, then you can claim travel to the court that you're going to, providing it's not within 25 miles of chambers. Now, it's a similar guidance as it would be for the Crown Court, and similar expenses can be claimed. What you will find is that when you've finished the case, if you submit your claim on a form Crim 8, which should be in your system, it goes to the solicitors along with any of the taxation notes that you've undertaken, any work logs or any written work that you've done, and along with a fee note. Now, on assessment, the legal aid assessed the claim and taken into account all the circumstances, and they pay counsel. Counsel are paid direct, so you'll be paid on your remittance advice directly. It doesn't go to the solicitors, it comes direct to you. Now, what I tend to find is that the legal aid assessors normally provide a standard response, and that response is that they've matched it to the criminal VHCC rates of £70 an hour, and that they deem this rate to be suitable remuneration for you. Another standard response is that they normally disallow travel. Now, what I would say is this is not the correct approach according to their manual of guidance. Each case has to be assessed on the relevant circumstances of that case. So in my view, they shouldn't be sending out a standard response. So if you get the standard response, providing the circumstances of your case and the supporting evidence supports your enhanced fee application, which it should be, you should appeal these fees. Invariably, they go to an independent costs assessor who reassesses the claim from scratch. And depending upon the circumstances and the complexity of the case, it has been known that they will pay up to £105 an hour for junior counsel, or around £90 an hour. So as you can see, just by having a detailed note and explaining all the circumstances, you can be remunerated quite reasonably for these types of cases. So I think from my perspective, that covers things that could be looked at. What does the future hold? As we all know, there's an upcoming review on how fees could be increased. And the rumour is that possibly there could be an additional item for special preparation, in that you could be paid for preparing a case to go before the court. So there could be a little extra tweak to the special preparation. So if this does happen, then obviously there's going to be a greater need for taxation notes and work logs, explaining what you've been doing and detailing all the work that you've undertaken in order to justify this preparation. And it seems to me that possibly, are we moving down a road where the fixed basic fee is coming to an end? And on that food for thought, that's the end of my presentation, and thank you very much.
Thank you very much, Mark. Now, as everyone's getting food for thought, we've got the question and answers box for you to type in your questions. We've had 2 questions appear so far in the box that I'm looking at. I've also received in advance of the seminar 3 written questions, so the questions are coming in. Type them into the Q&A box rather than the chat box, and we will go to the question and answers after we've heard from Tom Little QC to tell us his views on the CPS fee scheme. So Tom.
Thank you, Adrian, and good evening, everyone. As Adrian indicated earlier, for more than a decade, I've had the joy of being the principal contact between the bar and the CPS in relation to fees, and sitting on the appeals fee committee. I see a number of appeals every year, most of which relate to the difficult question of what is electronic evidence and what is not electronic evidence, and the potential unfairness that can arise. I'm happy to take questions and answers about that, but I'm going to steer clear of that particular issue today. I am obviously not a clerk, and I'm obviously not a CPS employee, so you might be asking yourself what on earth I'm doing providing you with this guidance. But in fact, probably some of the best people at understanding the fee scheme as it is now, fee scheme E as well as the VHCC scheme, are those that undertake this work most of the time. Similarly, those who are least able to comment on it are often those that undertake this work most of the time. I'm always surprised by how good a limited number of barristers are at understanding every nook and cranny of the scheme, and how many are not. So what I'm going to seek to try and do, because there is not much of an update in relation to developments, although I'll come to the future at the end, is really try and set out 10 tips, that may be an appropriate phrase to use, or 10 areas where careful consideration needs to be given. I have been in consultation with the CPS fees auditors just to make sure that everything I was saying was correct, and to gain an understanding from them as to some mistakes that are made on occasions. But before doing so, it's probably important to say that there is, to a certain extent, much in common between some of the points that have been made this evening, even though they relate to the defence scheme with the CPS scheme, the need for some form of evidence on occasions. It is often easier, I think, on the CPS fee scheme to produce that evidence and for it to be produced contemporaneously, as I will explain in a minute. But in relation to those 10 tips, the first relates to unused, which is an area that's already been touched upon. There is now an automatic payment for unused material, which proceeds on the basis of a limited amount of unused material. But in any crack trial or trial case involving more than 3 hours worth of consideration of unused material, an hourly rate is payable. I suspect that it is not claimed nearly as often as it should be. It is far easier now for the advocate to stay on track of the extent of the unused material, because it will be on the digital case system, save for this point, which is that prosecution counsel in some cases are sent what is called counsel-only material. That is material which may have to be considered even before any disclosure is made. And of course, there will be consideration of potentially sensitive unused material, both in terms of a schedule and specifically the underlying material. In any case of substance, I find it difficult to think that prosecution counsel should not be claiming for the unused material, because they should have been doing more than 3 hours. So for any clerks who see that counsel is simply not claiming for that, 2 important points. The first is they should be. They may be complaining that actually they've only done 6 hours and it's going to take them ages to produce a log. Well, it shouldn't do. And you now only have to produce a log of the time spent on the unused material, not on the entirety of the case. So there is no good reason not to be claiming for that. The second and more significant reason, in my view, is that at some point in the future, consideration will be given as to the extent to which the unused material is being reviewed by counsel. And if it's not being claimed for, the assumption will be that the amount of time taken was 3 hours or less. And that is unhelpful on any view when more time is being spent, because there is an overlap in relation to the information that the LAA have as well as the prosecution have. So it does the bar no favors at all to underbill on unused material. And for me, that's probably the most important and significant area. Every clerk should be ascertaining why a claim for unused material is not being made in any crack trial or trial case. Second tip is really hearing record sheets. Nothing annoys barristers, I think, more than having to produce a hearing record sheet following a hearing. I well understand why that is, and being chased for it or being chased to confirm that you have stated what the custody time limit is infuriating. I'm probably in a relatively fortunate position at the Central Criminal Court in relation to the extent of assistance that we have. But the hearing record sheet is actually likely to be the significant underlying document, which will be the evidence that is required to support certain things. First of all, whether the trial has started or not, and that vexed question. Fee Scheme E allows far more claims to be made for the trial starting, as it were, when it is starting, than used to be the case. Meaningful progress must be endorsed on the hearing record sheet. Not much needs to be put on there, but if you don't write meaningful progress and set out what it is, you will find that it will take hours in order to try and support that claim after the event. But if you do it at the time, it will take a matter of seconds. And that really is linked to similar points that can be made in relation to CVP hearings. And as I have actually recently experienced during the course of a trial where a defendant was unwell, we had a number of Teams meetings with the judge on various days to deal with issues which were not CVP hearings, and unpicking those after the event proved more difficult than I thought that it would have done, because the court claimed on occasions that there had been no hearing at all, which was surprising given that the judge was appearing on Teams for that hearing. But it was because the court had not had to set up any form of CVP hearing. They claimed that they were blissfully unaware that we had been sitting when we had been sitting. So evidence, and evidence, I think, really is probably less extensive and less difficult to obtain for the prosecutor than it is for defence counsel. The third point, which is linked to this, is the question of a trial which doesn't become an effective trial by reason, for example, of a jury being discharged. That can often happen following the opening and then some issue in relation to the jury. Providing the trial starts within 7 calendar days, the whole thing will count as an ongoing trial. That actually happens more often than I thought it did, and can be claimed as a continuous trial rather than an ineffective trial followed by a shorter trial. So don't do yourself down in relation to that. Fourth, always think about the offences and the offence categories. At first, you may assume that more will be paid for what I might call the more serious offence, but it is not always so, depending on the relevant page count threshold. It is surprising how often people, for example, in a murder case, will assume that the murder charge will pay more. It may well do, but it may well not do if there are also perverting the course of justice allegations or bladed article allegations, depending on the page count. So always ask the question as to whether billing for the lesser offence may create a greater fee. Fifth, tapes. You're not paid, I think, unfairly for watching the examination in chief of a complainant on an ABE, nor for the 999, nor for the interview under caution. They are assumed to be within the fee. But you are paid an hourly rate for body-worn footage, for which there is more, and CCTV, for which in certain cases there is more and more. Again, you only need a log of that work, not the whole case. That, I have no doubt, is underbilled. Sixth, cracked trials and guilty pleas, when they occur in a multi-hander, are regularly underbilled by not focusing on what the better paid cracked trial would be. Seventh, and this is a subject on which I regularly have to liaise with prosecution counsel, you are paid an hourly rate. It's very modest, but you still get paid it for a unduly lenient sentence advice as trial or prosecuting counsel. I obviously liaise with them when I'm advising the attorney in those cases, and practically every time they always complain that they're not paid for this work, and they are paid for it, albeit at a low hourly rate. And I suspect that if more people knew that, they would take more care with the advices to a certain extent, because they are important. They're under time sensitive because of the 28-day time limit. But there is an hourly rate for rape acquittal advices, ULS advices, and terminatory rulings. Again, often not billed for. Eighth, VHCCs. They are cumbersome in some respects, but one of the main problems is a failure to agree the hours in advance. The CPS often apply a pretty crude page count assessment, which is not often the right assessment. I have never found the CPS to be difficult at all in relation to any negotiation about the need for increased hours, providing that takes place in advance. Or in addition, if it happens over a weekend because something runs over, providing you get the email into the CPS, even if it's not answered beforehand, you're always in a far better position. And I can say that from having sat on various appeals. The last two matters are really this. it is often failed to be understood that if a defendant is subject to a restriction order on sentence, that those cases are paid as Class A offences, so equivalent to a murder. It's a very good example of, albeit not that common, a disposal that does occur in a range of offences and for which payment is very different. And the last point is really a general point, which is that if the CPS push back, but you're right, you should pursue it. It is time consuming, it is frustrating, and often the amount of money involved may feel not worth the candle. But it is surprising how often I advise my clerks about a failure on the CPS in relation to my fees. I set out in short order in an email why they're misapplying their own guidance, and lo and behold, they pay the right fee, and that takes not very long at all. And they learn as a result of that process. The more often that you don't claim the proper fees, the less likely they are in the future to get it right first time. So there's a duty really on everyone to pursue proper appeals or challenges as and when. I only see the tip of the iceberg because most cases effectively settle before coming to the appeal committee. But those are the 10 overarching tips. In relation to the future, to a certain extent, it's wait and see at the moment, because the CPS are going to have to review what to do in relation to their fee scheme E in light of anything that happens following the current consideration as to what level of increase there should be to defence fees. So I've got nothing that I can say, certainly at this stage, to indicate what will or won't happen. But certainly in relation to my involvement with fee scheme D and E, there must be a reasonably good prospect that any changes made to the defence scheme won't be identically mirrored, but will need to create some form of parity for obvious reasons. But Adrian, that's all I was proposing to say at this stage.
Thank you very much, Tom. And we now move to the question and answer time. We've had a healthy number of questions so far. So we've had 3 written questions in advance, which I'll go to, and then I'll go through the 10 answers that have appeared in the Q&A box so far. I think if we answer these fairly briskly, there will still be time for further questions. So if you're sparked by something that Tom or the others have said, you have a question, type it in the Q&A box, and we'll do our best to come to you before the deadline close of 7 o'clock. So let's go straight to the first question, which we received in advance. The question was, is the defence claim dependent on the court log for the type of hearing? Cases are often listed for mention when issues of disclosure are dealt with and the fee is different. The listing of a case does not always reflect the work done in the hearing. If the primary source of evidence is the log, do we need to ensure that the court clerk hears representations on the effect of the hearing when making an entry in the log? Liz, do you want to respond first to this one?
Yes, thank you, Adrian. Basically, as an assessor, we're interested in is what does the log say actually happened? It doesn't matter what the case was listed for. What does the log say actually happened? If the log says that an application was made in respect of disclosure in terms of the principle of disclosure, then the full day or half day fee may be paid. We won't look at what was it listed for, but what actually happened, as we are aware that they can be listed for mention, but actually they're not mentions, they are disclosure hearings.
Thank you. And anything you want to add, Mark? I think you're on mute, Mark.
Unmute. The only thing I would reiterate is that it's not just a normal run of the mill. If it's listed for mention, oh, the prosecution haven't served this document, therefore I'm going to claim the fixed fee. It has to be, and I'm sure Liz will confirm this, it has to be a proper application for disclosure and proper argument for you to enable you to claim the fixed fee, not just a standard mention hearing where you say 2 words.
Yep.
Thank you. The second question we had in advance, in multi-handed cases, there's no transparency in the system so that you cannot see how others have been paid for the same work. Can the LAA cite any examples of cases where they have informed counsel's fees clerk that the claim has been underclaimed or missed altogether?
I can't cite any specific examples, but I am aware that if we can see that a claim has come in that does not claim all the elements that we see that counsel would be entitled to based on the logs we're looking at and the evidence that they have provided in support of their claim, we may send you a gentle note that says, we have paid your claim as made. You might wish to reconsider because you might be due an additional fee. This is a big hint that you have underclaimed. But what we cannot do is say, you should have claimed this, so we will pay you this instead. Because we don't know that something else might not have happened, and that is why you have made the decision to claim as you have.
Thank you, Liz. Any comments extra on that, Mark?
No, I don't think I can say anything on that one.
Okay, and then the next one, maybe Mark, you try on this one. Is a TNP, trial not proceeded, fee payable when trials are removed from the list the afternoon before they're due to start and instead listed for mention to refix?
In, I suppose, simple terms, no, you wouldn't be able to claim a TNP for that type of hearing because you've been given notice that the trial has been cancelled. If you look at paragraph 16 of the regulations, it does say that an ineffective trial fixed fee is payable in respect of each day on which the case was listed for trial but did not proceed on the day. So it tends to infer that you were actually at court, I have to say, on a floating trial, where you're actually at court, the case couldn't get on, and therefore it's adjourned off. Therefore, then you will be able to claim a trial not proceeded fee. If you've received notice, I would tend to say that it's not claimable.
Thank you. And now for the questions that are in the Q&A box. First one, I think this is for you, Liz, because I think it picked up something where you said in your presentation about giving how the clerk or the barrister could give the LA access to the DCS for the LA to check something. And the question is, how do we give you access to the DCS?
You will find that the caseworker says, please give access to, and they will give you an email address for that person. And chambers need to give access in the same way as they would give access to anyone else. So the administrator would give, for example, access to the case to particular counsel if they are instructed in the case. So you would invite us into that case as if we were another defense advocate, effectively.
Thank you. The next question is, I have a current case awaiting billing where the vast majority of the unused was CCTV supplied on a 2 TB, it must be terabyte hard drive. There's too much to upload to anything, hence why it came on a separate hard drive. The prosecution junior has provided a note as to what is on the drive, and I have done a work log and an AU1 form. Will this be enough evidence, as I have no way of uploading anything else?
If the prosecution junior's note says that there were X many hours of viewing material and your claim for unused is likely to be of the same sort of time or a reasonable, I won't say facsimile, but there's a reasonable correspondence between the length of the CCTV and your unused claim. That should be enough. But if it is not, what we may do is ask you to send in the additional drive to the office, and we can look at viewing it if that's a possibility. But if the claim mirrors the prosecution note, we should be reasonably okay.
Thank you. Next question is on the common platform and an exhibit. It says, more and more often fees are being refused because the LAA is saying that there's no proof of our attendance. This appears to be where common platform cases have been moved back to exhibit. We're constantly asked to provide attendance notes which contain sensitive information. Are there plans to fix this, as we cannot disclose these documents and we are annoying the courts and judges by asking them to confirm our attendance? Why, once we have signed the form to say our claim is accurate, can we not be taken at our word and on trust that we're not committing fraud?
Well, the reason we do trust you, but what we're saying is there have been mistaken claims where an advocate has thought, or the clerk has thought that counsel were in attendance on a particular day, and the claim came in, and we look at the records and we say, there's no record of counsel attended. We assessed that. We went back to and said, there's no record that counsel attended, and we get the answer back, oh yes, sorry, I shouldn't have claimed that. So we have to have that additional confirmation of attendance. It's not that we think you're lying, it's that we think that we have to accept the possibility there might be a mistake, and that is why we need the proof of attendance, because we also need to satisfy the National Audit Office that we have paid everything correctly. And so we need that confirmation, that proof that they can then also look at and say, there's definite evidence that counsel was there.
Thank you, Liz. And can you, they said that this happens particularly where common platform cases have been moved back to exhibit. Do you know about that? Is that something that's been thrown up, and is there an IT fix to that?
The reason that they get thrown back out, there are a number of reasons that cases might be thrown back into exhibit at the moment, because common platform is still being built, and therefore the facility to deal with this particular element may not yet be in common platform. So they throw it out into exhibits because that can cope with all the elements. But at the moment, because not every court is saying to counsel, you're in the in the robing room, log into exhibit again as normal for a hearing, and it's reliant on the clerks. Because if it was on common platform, you've got the professional check-in. Is that sort of disconnect in that whether you're able to check in or not. So it's a case of asking the clerks to log you in.
Thank you. And then we've got a question about the 3-hour unused material fee. And I know that Mark in his presentation said that only 80% of these have been claimed, and you do get a reminder pop up. But the question is, why isn't the basic 3-hour for unused material paid automatically for any case where there's no claim for more than 3 hours? Why isn't it an automatic thing? Why does the barrister or clerk have to physically fill in the relevant boxes?
Counsel may not want the fee. He may say, I had that, there was no unused. I didn't spend any time considering unused. And he's therefore decided not to claim. We don't pay what you don't want. We might not pay what you want, but we don't pay what you don't want.
Okay. And then next question, what is the correct guidance in relation to claiming the trial not proceeded fees? If a trial is listed and is pulled mid-trial and relisted to commence a couple of days later, Can trial not proceeded fees be claimed for these days when the case is supposed to be sitting?
I think that's much as
Awesome.
we've covered already. It's been removed from the list, therefore it's not listed, therefore the fee is not payable.
There is, I would say there is one potential, is that if the judge orders you to attend court for a conference with the defendants during those 2 days, these can be claimed as trial not proceeded fees. But other than that, there'll be no claim.
Thank you. Next question. If you want to apply for your case to be put into a different category than it would ordinarily fall into, is there a particular form for this, or do you simply submit your argument in the other information box on the online submission? Now, I'm not sure if this is a question for the defence scheme or the prosecution scheme, because I know that Tom in his presentation spoke about that where on the CPS side you can sometimes get a higher fee by claiming under not the initial category that you would immediately think of, but maybe both, we could have answers on both the prosecution and defence side on this one.
I suspect that this question is a defence question, but there's no particular form, or there's no necessity with the prosecution, because it all is based on what the offence is on the indictment. Although, having said that, there is the caveat that not every single offence is recorded. So let me rephrase that. Not every count that could be on the indictment is in the list of CPS offences, but I have never come across any difficulty in relation to seeking to argue any particular category rather than another. You just need to justify why an offence that's not listed is more akin to one category than another, and the CPS are normally pretty flexible about that in my experience. But if anyone has got any different experience about that, I'd be happy to speak to them about it. But there's no particular form to fill out as far as the prosecution are concerned.
Similarly, on the defence side, there is no particular form to fill in. You need to explain on your claim why you think that this offence should be rebanded. Now, again, if the offence is one that is banded already in the banding of offences document, it cannot be rebanded. The only things that can be rebanded are ones that are not listed and therefore fall into band 17.1 by default. Those are the only ones in which you can request rebanding. But you can request that rebanding just in the additional information section.
Thank you. Next question, and I think we might need some explanation on this. It says electronic evidence continues to cause problems. It's sometimes difficult to know if it is relevant until we've seen it. Is there any way of resolving this? So I'm assuming that it's referring to an element of the fee that will only pay for relevant electronic evidence, and therefore the question is, well, you don't know if it's relevant until you've read it. So can someone answer first of all as to when this sort of thing applies, and then secondly how to address the issue?
I can certainly have a go on that one if you'd like. I think this is probably dealing with cases where, for example, you've got a mobile telephone that's been seized and has been downloaded, and you've got a download that runs to maybe a couple of thousand pages, and some of that is a timeline, and some of that is sort of, there's all sorts of different sections on the report, but only we've looked at it and say, well, so some of them are relevant and some of them aren't. You can normally have a look at the report and flip through and say, well, all this is metadata. I'm not going to learn anything from this. you look at it and you think, that's gobbledygook. If you're looking at it and thinking that's gobbledygook and it's metadata, that's the sort of thing we're going to look at and say, this doesn't appear to be relevant. You could flip through that quite easily. It's the phone calls, it's the communication with someone else that is relevant. If you've told us why the metadata is relevant, and you can set out an argument as to why that was relevant and should have been and should be paid for, we will look at that and consider your argument and allowing those pages. But you need to tell us why.
Again, I can only reiterate what Liz has said. Is it's the more information you can give to the caseworkers, the better it will be to enable you to justify the payment that you're claiming.
Yeah, I mean, can I just say, Adrian, that obviously electronic evidence does cause problems on the prosecution side, because material that would be uploaded onto the digital case system as evidence, as I understand it, and it is on the DCS under Section J as exhibits, will be paid by the LAA as page count. But the distinction, of course, is that the CPS fee scheme has an enhanced fee and a non-enhanced fee, and electronic evidence is what normally tips the case, or may tip a case from one to the other, and the brief fees are significantly different. And the CPS scheme is still rather archaic as far as that's concerned, when it really was what proverbially became known as the golden discs. And the difficulty is that to a certain extent, the CPS are not accepting the reality, which is that this really is evidence in a different way than it used to be. But it rather draws on the example that's already been given, which is effectively that downloads now contain so much material, whether you've gone and you've paid your parking, maybe highly relevant in one case if you've got an alibi, but it would probably likely to be utterly irrelevant when you've got 4 years of detail as to whether you paid with this app or that app on your phone. And I suspect that the CPS fee scheme does need to look in the future at how it deals with what I would call proper electronic evidence, which is proper evidence rather than a mass amount of metadata or gobbledygook that is likely not to be evidence.
Yeah, and the other thing is, if it's served in Section J on the LAA report and it is electronic evidence, it shouldn't be automatically counted as page count. Some people do, but it shouldn't be automatically treated as page count, because it is by definition not a page unless it has been assessed as being reasonable to be allowed as a page.
Thank you. Now, both Liz and Mark covered in their presentations about the process for billing unused material. We've had a further question on this. When billing for unused material in defence cases, what is absolutely necessary to be included within our claim? I have billed a number of unused claims, however, seem to be having a lot of rejections and spending a lot of time going through redetermination. So what do you think might be the cause of this barrister or clerk having their claims rejected, and what's the tip for how they might resolve that?
Well, I would think, looking at the question, you need to ensure that you've got the unused material disclosure schedule supplied to the legal aid agency. That seems to be one of the things that can promote rejections. Also, I would suggest, as both Liz and I have said, that you give the caseworker access to the DCS if all the unused material is recorded upon there, so they can see it for themselves. And finally, if it's not all on the DCS, because I know some of the unused material is not always on the DCS, then upload whatever material you have that you deem to be unused material. You upload it to the secure portal, Galaxy Key, to either the AGFS team so they can review it, or If it's more than 30 hours, the CCU team. There's plenty of folders on the DCS bit in which for you to upload this information.
And don't forget your AU1 form.
Of course.
Thank you. Next question, when asked for an attendance note to prove counsel attendance at court, can a copy of the Crown Court Digital Case Systems memo screen be uploaded as proof?
I'm not entirely sure what that screen looks like, so I can't say for guarantee, but if it shows that counsel was at court at that particular hearing on that particular day, then it is fine.
I will confirm I have used the DCS memo screen to prove counsel's attendance because it does show that counsel's potentially signed in or has given details that they are available to attend. So yes, it can be used.
Thank you.
Thanks. Next question, can viewing body-worn video and CCTV be claimed by defence counsel on an hourly rate, or is it included in the brief fee?
If it's unused, it can be claimed at an hourly rate. If it isn't, it can't.
Yeah. Yeah.
Basically.
There's no mechanism in the defence case for claiming for CCTV or body-worn footage. I think it was removed by His Honour Justice Penry Davey, I believe, in one of the cost judge decisions.
Thank you. Next question, can you please clarify when defence counsel can claim travel under AGFS? So I think we're talking about the local bar rule here, are we?
Yeah,
Yes.
I'd imagine so, yes. So
It's
40 kilometres, isn't it?
yeah, it's if counsel's chambers is not within 25 miles or 40 kilometres of the nearest court, then you can claim travel. The Legal Aid Agency have got a spreadsheet that can be obtained from their website, which gives details of the local bars and the distance from that local bar to the various courts. It's a useful tool to have, as it also lists standard train fares for the various years travelling from the nearest station, the local bar station, to the nearest local court.
Thank you. Next question, can you please clarify whether defence counsel can claim for attending conferences with clients, both bail and custody matters?
The first 3 conferences with the client not held at court are included in the basic fee. Beyond that, the fee allows only for conferences if the trial lasts, I think it's 20 days or more, or if it's a crack trial, if it was listed for or expected to be a trial of 20 days or more, then as the depending on the length of the trial, some additional trial conferences may be claimed, provided justification is given, and those are pre-trial conferences. Anything else, I'm afraid we can't make an additional payment for. Travel to and from those conferences can be paid, but time spent in them, not.
I can only reiterate the importance of that. If you're attending a conference, it's travel time and travel expenses can be claimed to that conference if the defendant is in prison, or if you've got a justifiable reason that you're travelling to see a client who's on bail at the solicitor's office. An example of that be is the voluminous nature of the papers. You know, if there's hundreds of lever arch files of papers on the case, you can't be expected to carry all that with you. You may be able to justify claiming travel to the solicitor's office for a conference in those circumstances.
Thank you. Another one for Liz, going back to the claiming of a trial not proceeded for a conference that takes place when the case has been listed specifically for a conference with the client. Would the LAA pay a trial not proceeded fee? At best, I've got a SAF, standard appearance fee, and sometimes nothing at all.
Right. If we're talking about a case that had been listed for trial and remains listed for conference with counsel, if you or conference with the client, I hate to say it, but if it remained listed for trial, you get a trial fee. You get a trial day fee now. If it was taken off the list totally, you don't get anything. If it was listed, so it depends what it's then showing as. If it was listed for trial, you get a trial fee. If it was just listed for a mention, you'll get the mention fee. If it's not showing on the court listing at all, then you won't get anything.
Thank you. Next question. Can there be a Newton hearing even if no live evidence is called?
Yes.
Yes.
Yes. But we need to know what was in dispute, because if it doesn't go into the log, go onto it on the log, you'd need to explain to us why this should be payable as a Newton.
Yes, it would need to be, again, as much information as possible, but yes, you can have a Newton hearing without live evidence, because it's to determine an issue that's arisen, usually on sentence.
Yep.
Thank you. That's a last written one we've got in. So we've got another 15 minutes left. So that's probably time for me to add in my crystal ball gazing, which is taking on from a bit of what Mark had spoken about on work logs. People have got till midnight tonight to respond to the CLAR or Claire, depending on how you call it, criminal legal aid review consultation. And there's a couple of questions on that consultation which raise the possibility of barristers having to do more work with work logs. So question 63 was saying, in addition to increasing the hourly rate applicable to special preparation, Claire recommended broadening the circumstance under which this enhancement can be claimed as the optimal method of supplementing brief fees or fees for individual hearings where an advocate had to undertake preparation in excess of the norm. And question 72 in the consultation says, Claire further recommended changing the prescribed circumstances under which wasted preparation can be claimed by reducing the qualifying threshold for a claim from 8 to 2 hours of preparation. Were this recommendation to be implemented in full, the effect would be to make wasted preparation available in significantly more cases than currently. So obviously we don't yet know what will be the government's response to the this consultation, but there's a possibility that there will be a broadening of cases of wasted and special preparation, which would therefore likely mean barristers having to submit more evidence of such preparation. I wonder if Mark, well, I think maybe Tom might want to talk about how likely barristers are to be inclined to supply this evidence, and maybe Mark might want to say about how practically the different computer systems could help with time logging and so on. So who would like to give their views on this possibility?
I'm happy to. I think it's hard to answer the question you've asked generally, because barristers vary infinitely. Those that do a significant amount of VHCC work, or used to do a significant amount of defence VHCC work, actually become pretty good at it, and you get used to it. And I think that if that's the direction of travel, I'm afraid we can't just put our hands up and complain about it. We'll have to work with whatever the position is, and it's naive to think that it's not beyond the wit of people to be able to complete these logs relatively easily once you get the hang of how to do it. And there are all sorts of ways of recording one's time now that are far easier than maybe they used to be, when everyone would write down on hundreds of different pieces of paper what they had done and then come back to put it in a log in due course. So the short answer is that if this is what's going to happen, then we're going to have to do it whether we like it or not, Adrian.
Just going on from that, I'm aware that both the diary systems, both Lex and MLC, they do have a time recording feature built within them that members can use. They can open a specific individual case on the system. They can click, I know on Lex it's a stopwatch. I think on Meridian it's another little button that you can press, and it will either record the time as in fact you are actually doing the work. So if you click the stopwatch and start your work, click the stopwatch when you finish your work, it will record the time that you've actually spent on it. You then just need to do a quick one-line word along the lines of perusing whatever documents you were perusing. That then will be stored in a comment line at the back of the case, so that when you come to bill it, you've got your work log, because it can be exported onto an Excel spreadsheet, which could then be turned into a PDF document to submit to the legal aid agency as a contemporaneous work log. The second way of doing it is much akin to how you record your time. You can do your work, record the number of hours that you've done on that item of work, and then just record those number of hours again in the same bit of the software. It records the date. You can put in a brief précis of what you were doing, and you can put the total number of hours spent on it. The software then saves it, ready for your fees clerk to bill as your work log as and when you need it. So these facilities are there. There may well be an extra cost, a license fee to use them, but I think, as we've all said throughout our presentations, it seems to be the way that fees are going, and the legal aid agency will certainly need to confirm the work that you've done with a work log.
Thank you, Mark, and thank you to all our speakers, Liz, Mark and Tom, and also for Georgie for doing the technical things behind the scenes. The next seminars, our family seminar, legal aid billing seminar, is on Thursday at 5:30, and then the one after that, the civil one, is next Tuesday, and you can book your places on the Bar Council website like you did for this one. So click on the training and events tab and then calendar, and then you'll find those seminars. Mark's PowerPoint slides will be available afterwards, and all attendees will be sent a feedback form, so we'd be grateful to have your feedback. And the recording of this seminar will also appear on the website. So I now, after thanking everyone again, fall silent and wait for Georgie to terminate our conference.